What legal rights do same-sex couples have? Kate and Jane lived together as a same-sex couple with their 7-year-old son Jack. When Kate died suddenly without leaving a will, Jane was left fearing the loss of the home they shared together, as well as losing her parental rights over their son. Although Jack was Kate's biological child from a previous relationship, the couple had brought him up together as parents since he was a baby. The law in England and Wales has developed by mainstreaming the legal position of same-sex relationships and ensuring that couples have equal rights when their partner dies, regardless of sexual orientation. Additionally, a same-sex couple who are not married or in a civil partnership, or who do not have wills, do not have an automatic right to the assets in their partner's estate following their passing. This mirrors the situation with opposite-sex couples. As a same-sex couple who were cohabiting, Jane faced the same inheritance issues that affect opposite-sex cohabiting families. When Kate died, Jane did not automatically have the right to inherit any of their estate that was not in joint names. Everything that was in Kate's name alone would be held in trust for her biological son Jack until he turned 18. Children and guardians of same-sex couples. A child's biological mother will always have parental responsibility. As far as the partner who is not the legal mother is concerned, whether or not he or she has parental responsibility will depend on the marital status of the couple, and on how the child was conceived, in particular whether the child was conceived as a result of treatment in a licensed UK fertility clinic. As Kate was Jack's biological mother, and his biological father was not his life, whether or not Jane would be eligible to remain as Jack's guardian was not guaranteed. So not only was Jane dealing with the emotional turmoil of the loss of a loved one, she was now also dealing with the fact that she may lose her home and son. Sadly, the couple were not aware that these issues could have been avoided if Kate had left a will stating her wishes. If a couple wishes for the partner without parental responsibility to care for a child following the death of the parent with parental responsibility, then he or she can appoint the partner as guardian in their will. This will transfer parental responsibility on the guardian when the will comes into effect if the child is under 18 at that time. The circumstances described in this video is just one example and may not be specific to your circumstances. Guardianship, whether for opposite or same-sex couples, is quite a technical area and requires specialist advice. More information can be found at childlawadvice.org.uk/information-pages/testamentary-guardianship. When it comes to estate planning, same-sex couples who are cohabiting, and not married or in a civil partnership, have no automatic right to inherit from one another. So, for many same-sex couples, the first step in planning their will is to determine the status of the relationship to ensure that assets or property can be inherited in the most tax-efficient way. Be safe, not sorry. Whether you already have a will or would like to get the process started, we are here to help. Take advantage of our £100 coupon towards our will writing service or just ask for a free will review service.